Ready for dictation? Start. It is well settled that even if the accused does not plead self defense, it is open to consider such a plea if the same arises from the material on record. The accused need not prove the existence of the right of private defense beyond reasonable doubt. The Penal Code confers the right of private defense only when that unlawful or wrongful act is an offense. A person who is in imminent and reasonable danger of losing his life or limb may, in exercise of self defense, inflict any harm, even extending to death, on his assailant, either when the assault is attempting or directly threatened. Having regard to the above, we are of the view that the appellant reasonably apprehended a danger to his life when the deceased and his brothers started strangulating him after pushing him to the floor. As observed by this court, a mere reasonable apprehension is enough to put the right of self defense into operation, and it is not necessary that there should be an actual commission of the offense in order to give rise to the right of private defense. It is enough if the appellant apprehended that such an offense is contemplated and is likely to be committed if the right of private defense is not exercised. It was argued by Mr. P.K. the learned counsel for the state that the deceased and his brothers were unarmed and there was no need for the appellant to have used the gun. Given the fact that the deceased and the others were attempting to strangulate the appellant, it would have been unrealistic to expect the appellant to modulate his defense step by step with any arithmetical exactitude. This court has held that a person who is in imminent and reasonable danger of losing his life or limb may, in exercise of self defense, inflict any harm, even extending to death, on his assailant, either when the assault is attempted or upon being directly threatened. We are inclined to think that the appellant had been put in such a position. We have no doubt that the appellant exceeded the power given to him by law in order to defend himself. But we are of the view that the exercise of the right was in good faith in his own defense and without premeditation. In this regard, it would be opposite to reproduce the observation of Sessions Court, which is as follows.